opening it up to yeah, more than that. So.
It's good to see you. Yeah, we'll talk later, okay? Would you like some water? You have some water.
I do. I have the
Would you like water
non-clinking
in a
kind.
glass?
I know, a glass would be better, wouldn't it? Less reactive.
Would you
but
like
you
some?
know what?
I just think it actually feels better on my
It does.
lips.
It does. I'm with you. Okay, and actually these are non-clinking glasses because they have these lovely coasters. All right,
I'm going to upgrade you.
Thank you.
So Renee and I have actually debated a number of times, but this is the first time we've actually ever met. We've actually
Really?
worked together.
This is funny. We
yeah.
wrote a piece together.
Yeah,
We did,
yeah, for the interactive
Thank you.
Constitution. And, yeah.
Wow, that is a testament to
world,
modern
right?
technology,
It is,
right?
isn't it?
Yeah.
Well, here's your interlocutor. There you go.
There you go.
When you debate someone multiple times, do you feel like
Well, it's not really. I think we've only debated the one time, and then we debated via paper the other time.
it counts for my purposes?
Okay.
Do you prepare new zingers for, like you think, I thought of a good rebuttal, I'm going to use it next time?
Yeah, I think so. Probably. I mean, you always want to get your best stuff in.
Yeah,
no zingers. I think both of us.
We're not
pretty
really.
much, we pretty much understand the arguments.
They wouldn't bear, yeah.
Yeah.
I mean.
So.
Oh, you mean sandbagging? Suja is the queen of preventing sandbagging.
Really?
Suja, she tells me and presumably others in advance what her arguments are.
You can definitely read and hear about any
norms.
argument I ever had.
What remarkable norms of fair play.
No, it's, what it shows that she's serious about debating, right?
Yeah, right.
And she wants a real debate on an important topic.
Right.
You're very generous.
No, it's true.
Yeah.
Well, I think if I'm ever in this position, I'll be sneakier. But I admire your standards.
You philosophers, I tell you.
Yeah, there you go. No standards. Everyone welcome. My gosh, I'm mic'd up, aren't I? It's time for us to get started. My name's Josh Kleinfeld. I'm just the moderator here. Just make a few quick announcements and introductions, and then we'll get going with your real guests today, Suja and Renee. One announcement is important. Apparently the temperature in the room where proceedings were scheduled to take place is cold. There's some sort of temperature problem in that room. I grew up in Alaska. I understand that you're rivaling my home state right now, so we don't want that. So the remainder of the Federalist Society proceedings will take place today on the 4th floor in the Cyril Magnin room number 3. That's the Cyril Magnin room number 3 on the 4th floor. The other thing, which is an announcement, but a minor one, just an apology, you're going to see me on my phone a lot. And I realize that I shouldn't do this. It's not that I'm checking text messages or emails, it's that I'm keeping time. And I think in the future when I moderate, I'll wear a watch. Sorry about that. All right. An Apple Watch, yeah, there you go. So the 20th century has seen a massive transformation in our legal system. In the founders' America, the jury was a constitutional actor. Suja, in her book, refers to it as a fourth branch of government. It was, in any case, a indispensable component, as the founders thought of it, of the third branch of government. In Tocqueville's America, the jury was a part of our legal and also our cultural landscape and a central repository of popular democratic control. It's hard to know when the decline began. Numbers are not easily available. And it's hard to know what the points of acceleration or inflection were. It appears that the 1930s were an important one, but in any case, it is the case at present that less than 1% of civil trials are resolved by jury, civil cases are resolved by jury. And 1 to 4%, depending on the jurisdiction of criminal cases, felony cases are resolved by jury. So that is to say that the jury has all but vanished. I think when histories are written of American law, they will say that the 20th century was the century where the jury trial ended, with scarce exaggeration. And yet the ideas and the formal rules and the cultural significance of the jury hang on and continue to affect the way our system functions as a practical matter. So with the transformation this massive in view, it's important to get some normative clarity about what's happened and what we should think of it. What in particular we should think of it as members of Federalist Society. For this purpose, no one could be better suited than Suja Thomas and Renee Lerner. Suja has written a book and numerous articles on the subject. She graduated from Northwestern, not my alma mater, the place I currently am a professor. She graduated from Northwestern with a BA in mathematics and from NYU with her JD. She clerked and then spent 8 years in private practice, entering academia in 2000. She's now a professor at the University of Illinois College of Law. Her book and her many articles are diverse, but I think the characteristic of them is a historical and often originalist orientation that exhibits concern with our departure from the historical Constitution's vision of the jury. And her book is consistent with that, The Missing American Jury, Restoring the Fundamental Constitutional Role of the Criminal, Civil, and Grand Jury with Cambridge Press in 2016. Renee went to Princeton and got a AB in history, then to Oxford as a Rhodes Scholar, where she continued her historical studies, and then to Yale for her JD. She clerked on the DC Circuit and the Supreme Court for Justice Kennedy, entered academia, joining George Washington, where she's been since, except for a stint in the Justice Department. Her work is characteristically historical and comparative, focused on the development of Anglo-American and continental institutions and procedures. And her most recent book is History of the Common Law with John Langbein and Bruce Smith. And with that, I'll turn it over to Suja first.
Thank you, Josh, and also thank you to Lee for this invitation. It's my pleasure to actually have the opportunity again to engage with Renee on this important topic. So given the passing of Justice Scalia, I think it's important to take stock of the role that originalism should play in the interpretation of our Constitution. And today we can use the jury as an example of how we can look at the future interpretation of the Constitution and originalism. And we know that Justice Scalia used originalism many times in interpreting the authority of the jury. And I'm going to discuss how it can be applied even further in this arena. The jury doesn't play the important constitutional role that it should play in our government. Instead, the executive, the legislature, the judiciary, and the states have largely usurped the jury's role. And I'm going to talk about this infringement and how the jury's authority can be restored. And so what I want to start with is the historical origin of the jury in the United States. It was based on the vibrant English jury. That jury was such that grand juries decided whether serious cases should proceed. Juries decided whether defendants were guilty of crimes, and juries decided whether monetary damages or fines should be awarded. But despite this history, as Joshua mentioned, juries decide few cases in the United States. Again, the stats are around 1 to 4% of criminal cases filed in federal and state court, less than 1% of civil cases filed in federal and state court. And then in many states, there are no grand juries for serious crimes. And this is only part of the story, because even when juries decide cases, their authority can be taken away. And so in the book that Joshua mentioned, which is what I'm going to be discussing today, the subject of the book, I discuss both of these phenomena, and I discuss how this has all happened to the extent we can tell, and how the jury can be restored. A caveat to this is I don't talk about arbitration and settlement because I don't think there's a constitutional dimension to them. And so let me start with a few examples to kind of give you some examples of how the jury's authority has been infringed. So one of my favorite examples is a case or a situation that involves Mark Cuban. I always like to mention Mark Cuban in my talks. He gave me a blurb. So in 2013, there was a case that Mark Cuban had against him. The SEC brought a civil insider trading case. And Cuban could have settled, but instead he went to a jury, and the jury found him not liable of insider trading. But around this period of time, Congress decided that the SEC should actually decide these cases itself, And the SEC started deciding these cases itself, and it started to, you can imagine, win more often. And so this is a classic example of a shift of authority from juries to another part of government. Here, the executive is both the accuser as well as the decider. Back in the day in England in the late 18th century, it was never the case that the government could actually perform both of these roles. The next example I want to give you is summary judgment. All of you know summary judgment is a procedure a judge can use to decide what a reasonable jury can find. We see this procedure used a lot in civil rights cases. In employment discrimination cases, almost invariably, an employer will make the motion for summary judgment, and over 70% of the time, the motion is granted. And this procedure is used a lot despite the fact that in England there wasn't anything like this procedure. So before trial there was a procedure called the demur to the pleadings. During trial there was a procedure called the demur to the evidence. And after trial there was a procedure called the new trial. And the only procedure that was at all similar to summary judgment was the new trial. And there you could test the sufficiency of the evidence, which is what we do on summary judgment. But you actually had to have it after a trial, and the judge would order a new trial. And so in an article in the past and in the book, I argue that summary judgment is unconstitutional. The last procedure I want to mention is plea bargaining. Plea bargaining occurs in around 95% of our cases. As all of you know, when a prosecutor offers a plea, that sentence that's attached to the plea is much less than the sentence that's attached to when you are convicted before a jury. And so that disparity is used to convince someone to take the plea. And as I said, through the stats, that's what happens most of the time. Well, in the Bordenkercher case, the Supreme Court said in a 5-4 decision that, at least in reference to what happened in the Bordenkercher case, that plea bargaining wasn't problematic under the Due Process Clause. Tim Lynch of the Cato Institute has challenged that in an article in Regulation. And in fact, if we look at history, there was no procedure like plea bargaining that was used back in the day. In fact, as John Langbein has said, virtually everyone insisted on taking their jury trial. So I think plea bargaining is also constitutionally problematic. And so in all these examples, what I'm saying is that you see a decrease of the authority of the jury and the increase of the authority of other parts of government. And this is all in the presence of 3 different provisions of the Constitution that provide for significant authority in the jury. We know the grand jury provision provides no person shall be held for a capital or otherwise infamous crime unless on a presentment or indictment by a grand jury, except in certain very specific circumstances. And so despite the fact that we have this provision, and despite the fact that almost every other provision of the Bill of Rights has been incorporated against the states, we haven't incorporated this provision against the states, and as a result, over 25 states don't have grand juries for serious crimes. The next provision I want to point out is Article 3, Section 2. It says, in I think no uncertain terms, the trial of all crimes, except in cases of impeachment, shall be by jury. Despite that, over 95% of our cases are plea bargained, as I said before, and I think that's problematic under Article 3, Section 2. I think it's shifting authority to prosecutors as well as legislatures. And despite this provision, judges actually decide many of our cases. So also I think that's problematic constitutionally. And then the final provision in the Constitution that provides for jury authority is the 7th Amendment, right? And the 7th Amendment provides in suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law. So you probably all know this, but the only place in the Constitution we refer to common law is the 7th Amendment. And the Supreme Court has said that common law in the 7th Amendment means the English common law in the late 18th century. And so when you're looking at the jury and what the jury is supposed to be, the civil jury, you're supposed to look at the late 18th century English common law. And despite that, the court has not adhered to that. In England in the late 18th century, juries decided damages. And despite that, we have things like that's going on, like the example I mentioned, the SEC example. We have also procedures like summary judgment, judgment as a matter of law, remitted, all of which didn't exist in England in the late 18th century. All right, so with that said, we have all these provisions in the Constitution that provide for jury authority, but the jury decides few cases, and so why is that the case? One thing I want to point out is that the jury is unlike all these other parts of government. The jury can't actually affirmatively act when another part of government takes its authority. So if a judge decides summary judgment, it's not like the jury can say no to that, right? And so we always have had the case that the jury's had this characteristic, but the jury has held authority at various points in time, so that can't answer the question for us. So I think we have to look to the Supreme Court and how the Supreme Court has treated the jury versus how the Supreme Court has treated other parts of government. And so when we look at how the Supreme Court has treated other parts of government, the Supreme Court has created doctrine, separation of powers, and federalism to actually protect the authority of these other parts of government. There's text in the Constitution that protects them. Their founders said that they were supposed to actually protect against each one another, and then the court actually put together this doctrine. But the jury looks exactly like those parts of government. There's text that protects its authority. The founders talked about it as a protector against parts of government, but the Supreme Court never created doctrine to protect its authority. And so what we see is over time that because of this, I argue, that the court actually decides in favor of jury authority and then decides against jury authority on issue after issue. And I have a graph in my book that shows this. And so I'll give you two examples, one on the criminal side and one on the civil side. One, in the Thompson versus Utah case, the Supreme Court said a criminal defendant can't waive his trial of 12 jurors. But in 1930, the Supreme Court said a criminal defendant can waive his trial of a jury. And then in 1970, the Supreme Court said, and it doesn't have to be 12. Then, in a civil case in 1913, in the Slocum case, the Supreme Court said, once a jury tries a case, and if the judge thinks the evidence is insufficient, the judge can order a new trial, but the judge can't fine for the other party. After that decision, the Slocum case, the ABA, some segment of the ABA at least, wasn't happy about that, and they had a committee formed. And then in 1928, Justice Hughes, actually not Justice Hughes at the time, but Charles Evans Hughes, who had been on the Supreme Court and was in a dissent in Slocum, said in a very public forum, said, our progress for the administration of justice lies not with juries, but with conscientious, able judges who are better served, to decide these types of cases. And then we find in 1935 that the court in Redmond essentially reverses itself, and it says, okay, once a jury decides, and the judge thinks the evidence is insufficient, that in fact a judge can decide against what a jury found. And so as a result, the Supreme Court essentially made the civil jury an advisory jury. So around this period of time, what's going on? And so it's a difficult question. We have, I think, a lack of use of doctrine to protect the jury's authority. We have the influence of legal elites like Charles Evans Hughes. We have an increasing diversity of the jury that I think is probably playing into this, and why judges maybe potentially, or legal elites possibly, do not want juries to decide. It's a difficult question, but I think this is some of what's going on. And the final thing I want to say is just, I think we can restore the jury. I think that we need to eliminate jury infringing procedures. I don't think there's any real way to do this outside of that. I know it sounds like a radical statement, and it's going to take resources, but I think it's actually what the Constitution actually requires. So I want to now turn it over to Renee.
All right. I'm going to speak from the podium because these days I have trouble thinking sitting down. And this way I can see you all too. It is a great pleasure to be here, and thank you to Lee Otis for organizing this. Lee, I was thinking of some epithet for you, and I was thinking of the ultimate fixer. But then I was thinking that has connotations that are maybe not so good. So maybe I'll just put it this way, a good fixer. And thank you also to Christopher Goffos for keeping us all organized. And I'm glad that Josh Kleinfeld is moderating this panel. He will add an element of philosophic rigor to this debate. I think Suja and I can add some of that, but Josh is the expert in that department. It is a special pleasure to debate with Suja Thomas. Professor Thomas and I disagree vigorously about juries, as you will see, but one could not have a more delightful opponent. Suja is thoughtful, generous, and takes great care never to sandbag someone with an unexpected argument. And I think that that is the sign of someone who wants a real debate about an important issue. And so I'm very glad to be debating her. In her book, Professor Thomas describes that the founders held juries of all kinds in great esteem and embedded them in the structure of government, particularly, of course, in the judiciary. And indeed, many of the founders did heap praise on juries, though some of them had significant reservations, as I'll discuss in a moment. Well, of course, many of the founders liked juries. Revolutionaries in all sorts of places have liked juries. If you are under a colonial or imperial government with no popular representation of your people, juries are looking pretty good. They at least give you some means of popular participation in the government. And if your revolution is successful, this warm, happy feeling about juries continues for a brief time. Even the French, during their revolution, introduced juries. Elites in India, under the British Raj, praised juries, but then quickly abolished them after India achieved independence. The story was similar in many respects in America. There was great revolutionary enthusiasm for juries, but after that, we have gone, as Professor Thomas describes, a long way in the United States to eliminating juries. An important difference with India is we can't totally eliminate juries because they are enshrined in the federal and state constitutions. Besides that, many members of the powerful American legal profession have a financial interest in keeping the jury going, at least nominally. For the moment, I'm going to focus on civil juries and address criminal juries and the grand jury later. There is a reason why civil juries either have never existed or have virtually been abolished in every other country. Even England, the birthplace of the civil jury, and its former colonies of Australia, New Zealand, and Canada have abolished the jury for almost all civil cases. Persons in legal systems all over the world have recognized the main problems with juries: expense, bias, incomprehension, and most of all, unpredictability. These flaws did not escape the notice of our founding generation. Soon after the American Revolution, the Federalists recognized these problems, and several of them argued strenuously against having the right to a civil jury in the federal Constitution. In the new republic, state juries were known for sympathy toward debtors and verdicts against creditors. In effect, they nullified the laws of contract. James Madison was alarmed and worried that these verdicts would discourage the investment the new republic so badly needed. In the Virginia Ratifying Convention, Madison argued against the need for a right to federal civil jury trial. Alexander Hamilton did also in the Federalist Papers, and he made that argument most strongly in Federalist number 83. There was, therefore, a great difference of opinion among the founders about the civil jury. In contrast, virtually all of the founders, I think all of the founders, agreed that there should be a right to a jury in criminal cases. And that right, of course, is found in two places in the Constitution: in the body of it, as Professor Thomas said, Article 3, Section 2, and, of course, in the Sixth Amendment. I guess to make assurance double sure, as Macbeth said. Of course, in the end, the Anti-Federalists won on the civil jury point. James Madison was concerned that without a Bill of Rights, that included a right to civil jury, that a second constitutional convention might be called. and so he reluctantly drafted the Seventh Amendment. But as soon as the founding era was over, judges and legislators began limiting civil jury trial. In the 19th century, Americans in all areas wanted to encourage commercial development through predictable, uniform legal rules. Use of civil juries could lead to unlawful, unpredictable results that undermined the authority of legislatures and courts and thwarted the ability to plan and carry out actions. There is a fundamental tension between juries and the rule of law. This kind of thing is happening today in many industries. One of the most recent is actually in the trucking industry. The number of persons killed in accidents involving large trucks fell 20% in the last decade. One would think that, therefore, insurance premiums would have fallen too. But that is not the case. Two major insurers have pulled out of insuring trucking fleets in 2016. And the ones who are left have raised premiums anywhere between 10 and 30%. Why? Because juries over the past 5 years have started awarding tens or even hundreds of millions of dollars to families of accident victims, much of it in punitive damages. Jury verdicts in this area have grown so unpredictable that it's had a major effect on the insurance industry. Some small trucking fleets are in danger of going under completely if this continues. And of course, we'll never know how many were not started because of this. And the trucking industry is not alone. It's no wonder that litigants avoid juries. So here we are with virtually no litigants wanting to go to jury trial. Settlement rates, as you know, are enormous. Jury trials are too expensive and unpredictable for litigants to want to risk it. So what do we do now? The constitutional provisions concerning civil jury trial block the proper adjudication of cases by judges. The cleanest and best thing to do would be to repeal them. Assuming, which I think is a safe assumption, that that is not going to happen anytime soon, there are sensible ways to interpret many of the provisions to give more flexibility. In the Seventh Amendment, the term suits at common law originally meant suits between limited parties for limited numbers and types of claims for money damages. We can go back to that, and the legislature can determine what to do with the rest. Then what? Then we should set up a system for proper judicial adjudication. There are many examples of how to do this from other countries. The English, the Germans, and the Australians are not barbaric or anti-democratic because they do not use civil juries. Other countries are well aware of the main danger of judicial adjudication, and I'm sure it has occurred to many of you as well. The biased, corrupt, lazy, or incompetent judge. Other legal systems take steps to guard against this danger. What do? One of the main safeguards against judicial bias in countries that traditionally use judges to resolve cases is having a panel of judges in the first instance, rather than a single judge. These panels allow colleagues to correct a biased judge. And besides, several heads are often better than one at legal decision-making. And this is an argument that's often made by proponents of juries. A single judge is not the only alternative to a jury, as many proponents of juries assume. Now, one advantage of jury trial is that at least a jury has to make a prompt decision. Deliberations do not drag on for months. Some judges, to be sure, will need encouragement to keep cases moving and to make prompt decisions on the merits. These incentives should include time limits and review of performance by judicial peers and superiors. One of the most important changes in shifting to judicial adjudication is that decisions on the merits would be accompanied by written opinions explaining facts found, the reasons why, and the application of law to facts. Juries do not give official reasons. And in fact, the nature of the lay jury makes it very difficult for them to do so. And finally, a thorough appeal. A thorough appeal is a vital safeguard in legal systems that rely on judges to make decisions. Appeals in these systems are often de novo, with no presumption of correctness attaching to the decision below, and of fact as well as law. Let me repeat that. Appeal de novo of fact and law. These systems are thorough in guarding against error in decisions on the merits. Our limited appeals are a legacy of the jury system. Now, the system I've just described may seem very different from the one we use in the United States, but it actually exists, or something very like it, in the PTAB. That is the Patent Trial and Appeal Board of the U.S. Patent and Trade Office, established in 2012. I am going to say that the PTAB is the Valhalla of civil procedure in the United States. Now, I know that several of you are experts in patent law, and it'd be interesting to get your views on that. But in the view of this person who studies juries, it looks terrific. Why? Because the PTAB adjudicates issues of patentability using 3-judge panels composed of expert and independent judges with requirements for written decisions, strict time limits, and thorough appeal to the Federal Circuit. Not surprisingly, the PTAB has already, in its short existence, proved to be a success with litigants. That is the way to do civil adjudication. Thank you.
We now have rebuttals. It's Suja's turn.
So I agree with Renee that like with other parts of government, that we can use other countries' systems and changes to how our government has changed throughout time to kind of figure out what our system should look like. But with that said, we have to do this with reference to the Constitution. And any change has to occur within the constraints of the Constitution. And I think we know that the jury is given authority in the Seventh Amendment, because Renee, I think, limited her comments to the Seventh Amendment, the civil jury. And so until the Constitution is amended, I don't think that her proposal of having judges decide is actually possible constitutionally. And I think that if we were actually to look at whether or not judges should decide versus whether juries should decide, let's say we actually were going to reinvent the system, I think we would still, at least as a society, not necessarily this group, or not necessarily any particular lawyer group or judge group, I just don't know, but I think the public as a whole would continue to retain the jury system. And I think there's reasons why that's the case. It's the case that if you look at research that's out there, you see that judges and juries generally agree. There's study after study that shows that, and so in over 70% of the cases, criminal and civil cases, they'll generally agree. And so you often will get agreement, and so that shows some kind of, I guess, ability in the jury, I think. We also know that there are studies that show that if you look at judges and how they actually evaluate evidence, judges actually have trouble with ignoring inadmissible evidence. Chris Guthrie and others have shown this. They've also shown, Chris Guthrie and others have also shown that judges are subject to some of the same heuristics that regular people in the public are. So they, for example, go towards an irrelevant figure, a term called anchoring. So we know judges and juries actually have some of the same problems. And then if we think about diversity, if that's something that we actually value, we know that the federal judiciary, for example, and as well as the state judiciary, is not as diverse as the general population is. So, for example, we know that the federal judiciary is around 85% white versus 75% of the general population. We know that the federal judiciary is around 75% male versus 49% of the general population. And the state judiciary is similar. And so if we value diversity, I think we would value juries, because although juries are not going to exactly map the general population, they're going to map the general population more than the judiciary does. And then I think that if we think about this also in terms of what we have in our systems, if we look at how we screen jurors, we actually screen jurors using voir dire, right? We have lots of people looking at whether or not a juror is actually biased or not. But if we look at the executive, the legislature, and the judiciary, they actually self-screen, and we see problems with that over and over. It's the case that there was a case, some of you may know this case in Pennsylvania, out of the Pennsylvania, the Supreme Court decided it in the last term. And there was a prosecutor, and the prosecutor recommended the death penalty in a case. And then some years later, many years later, that same prosecutor became the Chief Justice of the Supreme Court of Pennsylvania. And he was asked to recuse himself because the question was whether or not to reinstate the death penalty. And he refused to recuse himself. And I used the example to show that we all have trouble screening our own bias. And this judge did. And this is the way the screening mechanism is. And then just a couple more very quick points. If we look at incentives, and you look at incentives of jurors, for the most part, there's really no incentive in the typical case. But if we look at the executive, the legislature, and the judiciary, there's re-election incentives, there are promotion incentives, you have repeat players coming before you. And so I actually think that for many of these reasons that I've just mentioned, the founders picked the jury, right? They didn't think it was perfect. They didn't. They talk about that. They didn't think it was perfect, but they thought more wrong could be done. Thomas Jefferson said this, that more wrong can be done without the jury. So with that said, I'll turn it over.
Okay. I guess there's a fundamental question here. What are juries for? Right? Why do we have lay people participating in adjudication? And there are various possible answers. Tocqueville, in Democracy in America, praised the jury, actually the civil jury he was mainly talking about, for an interesting reason. He said, when you consider the jury as a judicial institution, it falls short. In other words, the jury is not good at deciding cases. He said, the reason to have a jury is that it educates the citizens, that the members of the jury themselves can learn something from this process. Well, of course, now hardly anyone serves on a jury. So that's a difficulty. So what is it for? Professor Thomas says in her book, it is designed as a check on other branches. Of course, in the federal system, we have 3 branches, 2 of which are elected by the people, and that seems to be something of a check right there. And the branches check each other. So the question is, do we need juries to do this? Juries, I think, are too unpredictable, not reliable enough to serve as a check. In addition, they are not fully representative of the community. There's a real tension there, and Professor Thomas suggested this. There's a real tension between the idea of the jury as a representative body, a kind of a mini legislature that represents the community, and the jury as an unbiased decision maker. Because if you get a group of people together who are truly representative of the community, there are going to be people on there who are biased and who are incompetent. That's the way it's going to be. And in terms of the representation of the community, the people on the jury, of course, we know that in some jurisdictions, over 60% of people ignore jury summons, right? They toss them in the trash. I talk to my students about this a lot. Have you ever been summoned, and what did you do? Oh, I threw it out. Right? That's what most of them say. So there's that. Then, if they actually do show up in the veneer, Many of them have some wonderful reasons not to serve on the jury. That's the one place in America where people are proud to say that they are completely biased and could not possibly fairly decide a case. And there are some things that potential jurors do, like run off during a break in jury selection and buy unrefundable plane tickets and then tell the judge, "I'm so sorry, Your Honor, there's no way I can serve on this jury." But supposing that you actually show up and are willing to serve on a jury, then you get picked over by the lawyers. And the lawyers are not there to select a competent, unbiased jury. No, the lawyers are there to select the jury that is the most favorable to their client, however biased or incompetent they may be. So there's a real fundamental tension here about possible goals of a jury that I think are, in the end, unresolvable.
Okay, thank you. Thank you. That was wonderfully brief, too. So you caught me by surprise by actually staying within the time limit. So I'd like to begin. There's now a portion of the discussion in which I'll ask some questions, and then we'll open it up to the audience as a whole. There's an image in our culture of our own system as one in which we have popular participation through juries in the criminal trial, and the continental European systems of criminal procedure and civil procedure as ones that are inquisitorial, that are entirely in the hands of bureaucratic professionals. In both your work on this subject and Renee's work from a comparative standpoint in parts of Suja's book, there's a discussion of the emergence of lay participation in European continental systems and the persistence of some forms of lay participation in England. And so I'm wondering how radically false our image of our own system and of their systems is. And here's the way I'd like to frame it. Imagine a scale. On one end of the scale is a system of governance where final adjudication is in the hands of the laity, of lay citizens. Imagine another system where the entire process and control over the outcome is in the hands of legal officials or professionals exclusively. Where are we on that scale, and where are our peer nations of England and in continental Europe on that scale? How far to the radically professionalized side of that scale are we, comparatively speaking?
I'd like to, Josh makes an important point. And one that Suja brings out in her book. In the last section of her book, she has a set of descriptions of the use of lay participation in other countries. I'd like to make an important distinction here, though. Worldwide, there has been a flight from lay participation in civil cases. That's an important distinction. Whereas in criminal cases, worldwide, we see a turn toward lay participation. And I think that's an interesting phenomenon and tells you something, that there may be some real value to lay participation in criminal cases. So I'm going to use that as a segue into talking about a little bit about criminal cases. And I think that's for a couple of reasons. One is, as Josh suggested, the fear that criminal adjudication can become too bureaucratized, that it can be dominated by a class of people, a group of people, the judges, who may be removed from the experience of ordinary people in the United States or other countries. And I think that's increasingly a danger. I think increasingly we are roped off in various ways by class and so forth, in particular in the United States, and no longer have the kinds of interactions that we once did with people in different socioeconomic groups, for example. So I think for that reason, there may be some advantage to having lay participation in criminal cases, and because the sanctions are, of course, so severe, depriving people of their liberty and, of course, potentially death as well. So I think for those two reasons, there is something to having lay participation in criminal cases. I would say the best way to do it is the way it has been done in many countries that come from civil law traditions, which is a mixed panel of professional judges and lay jurors. The mixed panel hears the case together, they deliberate together, and they vote together. And in many of these countries, there is a requirement of a written decision. So the panel actually has to justify what it did, and there is full appeal of fact and law. And I think that that is an excellent system and one that we should work toward in the United States.
So it was really interesting, as was mentioned in the last part of my book, I talk about other systems throughout the world that use lay people. And it was really interesting to look at that. As Renee said, clearly on the civil side, we're kind of this anomaly. There's a few places that have some civil matters, including England, just a few that are decided by lay people or a panel of lay people and judges. But for the most part, what we're talking about when we're talking about some comparison is on the criminal side of things. And on the criminal side of things, it's somewhat been interesting to see that in some places, our system is kind of we have less of a system in the sense of less lay participation because sometimes the checks that judges actually have on juries is actually greater than in some places. So that's interesting. And then I'll go back to the civil side of things. One of the things I find most fascinating about this is that when you talk to people, judges from other systems, they're sometimes very, very surprised about our system. And the reason they are surprised is that all of the checks that judges actually have on the system. I've basically argued that the jury, the civil jury in the United States, is an advisory jury because almost every single circumstance is such that a judge can question what the jury actually found. And so, in other words, the jury actually advises and the judge can decide against what the jury found. And even in the circumstance of summary judgment, it's the case that a judge can take that case away from a jury. So I think the question's a really interesting one, and I really enjoyed looking at this issue, and I encourage everyone to buy the book.
But what is the answer? So in the criminal context, as compared to, say, let's take the four largest continental jurisdictions, Germany, I think in this order, Germany, France, Spain, and Italy. Do we have more lay participation and control in the criminal context or less than those four countries?
I would say less. Because of the. Can I
please,
explain why?
Yeah, I just want to make sure.
Okay. Because of our extreme reliance on plea bargaining. Plea bargaining is coercive, in my opinion, should be abolished. And it takes away the vast majority of cases from any kind of lay participation at all. Whereas in France, for serious cases at least, there is no plea bargaining. In Germany, unfortunately, some form of abbreviated procedure is creeping in. It consists of an agreement between the judge and the defense lawyer. So you'll observe that the key player in the US, the prosecutor, is not heavily involved in that arrangement. It's marginally better to have the judge so heavily involved, I think. But anytime you offer a defendant a discount on his sentence for pleading guilty, you are inviting coercion and you're inviting an innocent person or a person with an arguable case that he's not guilty to plead guilty. And so I think our extreme reliance on guilty pleas mean that we actually have less lay participation than in these other places.
So I agree with Renee on that point, and I would just say that if you have a mixed panel, I would say that I think that's going to be problematic. I mean, putting aside the Constitution, I think it's problematic because in some of those systems that have this, certainly there's the goal of having those lay participants actually really participate in the discussion. But of course, as you might imagine, people who are judges are going to have more kind of sort of on those panels, and I don't think that they're equal. The lay participants aren't equal, I think, participants on that panel.
Okay. So my next question, it's got two parts. I'm wondering if we can characterize or identify whether and how juries reason, which is different from how judges and other legal professionals reason. So what I have in mind here is this. there are different ways of being rational. Max Weber famously argued that modern law is characterized by instrumental rationality, a term I believe he coined. That is where you identify some end and try to find the most efficient means to that end. And by formal rationality, where you're rational insofar as you're comporting with some sort of rule. He contrasted that with value rationality, where you're rational insofar as you're trying to live in accord with some set of values. I'm wondering if we can say of juries, well, they reason differently from judges. And here's how they reason differently. They tend to be more value rational, or they tend to be or judges tend to be more formally rational, or prosecutors tend to be more instrumentally rational, or something else, some other characterization. I mean, presumably, if the difference between judicial and jury decision-making matters, it matters because they think differently about cases. So what do we know about those differences? The second part, and a related part of the question, is this. If they think differently, if they behave differently, presumably it leads to different outcomes in cases. Do we have any empirical information about what the differences are? That is, how do juries characteristically resolve cases? Can we say they tend to be more favorable to defendants or less favorable to defendants in, say, the criminal context, or something else in tort or contracts? You started to get at this, Renee, but it was quite historical. It had to do with how juries at the founding alarmed Madison with respect to the resolution of contract cases. What do we know about contemporary juries and the outcome on cases of restoring them? So two related questions. How do they think, and what are the outcomes?
Well, I mean, I think part of what I already said kind of goes a little bit to this. I mean, I think when we look at how they think, we can look at outcomes, and we can look at that at least the studies that we have show that judges and juries generally agree. In terms of differences, I wish I had these studies right at my fingertips. Maybe Valerie Hans, who's in our audience, can help us out on this, and maybe Renee knows. But I know that there are some studies that show sort of, punitive damages that juries can decide, sort of more favorably in higher amounts. I know that some of the studies show that when you're talking about damages and there's differences, that juries come out higher. None of these studies I've done myself. So we do see some of those differences. But as I said before, we also see that they have similarities in terms of their problems. We do see agreement in terms of largely we see agreement. And then one thing that I just want to point out is that when you talk to judges, judges invariably say that juries get it right, that they very carefully consider cases and deliberate conscientiously. And then, this is sort of an aside, but I'll mention it, that once jurors actually sort of participate, because there's been mention about how people throw away summons, they go to jail for that, by the way. Don't they?
In that case, my students would be in jail.
I don't know. Anyway, that they actually, lost my train of thought, that they actually really enjoy, right? They enjoy participating, and this is a really important thing to them. I remember my husband coming back from jury service and really, and my sister, and so people really enjoy this. I mean, yeah, they try to avoid it, but anyway, that's an aside. It doesn't go directly to your question.
Renee, do you want to add something to on this point?
Yes, I knew that Josh's philosophical rigor would come out, and sure enough, in this question, it certainly did. We're fortunate to have with us Valerie Hans, who who has done a great deal of empirical work on juries, and who also is now writing a paper about reasoning, and in particular, I think, jury reasoning. And so I'd like her to give us some insights in just a second. I'm going to have a few things to say, and then hopefully, is that all right? If
more expertise.
Professor Hans, who is an expert on this, so we're lucky to have her here. But in any event, a couple of things. So there are, it says, In many empirical studies, it's shown in the majority of cases, it appears that judges and jurors would agree on questions about liability. Now, when we say majority, we're talking in the vicinity of 70 to 80%, which would still leave a large number of cases that would be differently resolved. So there is that. Also, you have to wonder a little bit about the methodology of these studies, because it's not as if the judge is having to make an independent decision and being forced to make it without having a jury there. So it's a little bit tricky. You're comparing apples and oranges. These studies are not necessarily entirely indicative of whether there are, in fact, differences between judges and juries. But it's been fairly consistently shown, I think, that there are a few, or several significant differences between judges and juries. One is on the civil side, an anti-corporate defendant bias on the part of juries. That has been shown quite consistently, that jurors tend to be biased against corporate defendants. So there's that. Then it has been shown that there are significant differences between judges and juries on the question of damages. And again, that's consistent across these studies. In general, judges would award lower damages. Not always the case, however. There are cases in which judges would award higher damages. So there are significant differences on the question of damages. On the criminal side, it's been shown fairly consistently that judges would tend to give, juries tend to give more lenient sentences. And that is shown too on these mixed panels. The effect of the mixed panels in the systems that use them is that the lay jurors do have an effect in reducing sentences in general. So there are those things. Now, I want to address a few points that Suja just mentioned. That judges in this country generally praise juries. Indeed, they do. They sing the praises of juries to the heavens. And why is that? They have great incentive to do so. Because juries relieve judges of an enormous amount of responsibility and work. Judges in this country, generally speaking, do not have to decide cases on the merits with reasoned decisions. It is hard work and responsibility to decide a case on the merits and then issue an opinion explaining why you did it. And so judges are very glad to have juries that will force the parties to settle, because nobody wants to go, or hardly anybody wants to go in front of a jury. So you will always hear a common law judge praising juries. Another thing about jurors enjoying their jury service, indeed, that is another quite consistent finding, that people who have actually served on juries do like it. No question about it. But go back to the early 19th century when we still held a fair number of jury trials. People hated it. They hated having to sit there and resolve somebody else's dispute while their crops were in the field needing to be harvested. Okay, this happened again and again. You see these complaints over and over in state legislatures and state ratifying conventions that jury service is a tremendous burden on the population. And now can Valerie say a few words?
Please.
Hi, I'm Valerie Hans. I teach at Cornell Law School, and I have indeed been doing jury research for a long time and empirical research on juries. So Renee, thank you for inviting me into your fascinating debate with Suja. It's really, really interesting. I'll just add a couple of things to your summary of literature. There's, I think, a lot of similarity in the way judges and juries think about cases, evaluate evidence. Some evidence might be more heavily weighted by juries, some by judges, but overall there's a great deal of similarity, which shouldn't be surprising for our trial judges in the United States. The differences that do emerge seem to emerge more consistently, as you said, in criminal cases than in civil cases. But looking at civil cases, I don't see in the research huge differences. I have done myself a small study, a judge-jury agreement study, where you ask judges who preside over jury trials what would they have done had they been deciding the case themselves. And I looked at cases with corporations to see whether or not juries were more likely to favor the person, a plaintiff suing a corporate actor as opposed to a ordinary human being. And a very similar pattern occurred in both judge and jury decisions, judge hypothetical decisions and jury actual decisions. In other words, I didn't see any pronounced anti-corporate bias among juries in those cases on liability judgments. On damages, I think we just don't know. I don't know of really strong evidence one way or another that says if a jury is deciding a particular case, the award will be higher as opposed to lower in a case. One of the problems with the research in this area is that the cases are selected to be by jury or by judge, and so juries often get the big bucks cases. They get very high dollar value cases, and so it's hard to separate the type of case, the selection effects, if you will, from the nature of the decision maker. So I've seen a couple studies where juries on average are higher, some where they're lower, and so I'm kind of I've concluded right now we just don't have the evidence in this case. Now, do they reason differently? I think judges really benefit from the experience of having decided a lot of other cases, and of course they know the law. And those kinds of things, in some instances, can protect them against some of the biases and heuristics that my colleague Jeffrey Klinsky and other scholars have documented that plague judges as well as juries and all the rest of us. So thanks for talking about some of the empirical questions that underline this really interesting debate.
You know, I had one more thing to ask, but then we'll open it up for questions, and you'll be first on the list. So the last question I had was there's a quote which Barack Obama is fond of, quoting Martin Luther King Jr. I don't know where it originates, but the arc of history is long, but it bends toward justice. That always struck me as optimistic, perhaps naive, but I do think the arc of history is long, but it bends toward social necessity. If you see in the 20th century, juries go from the basic characteristic of our system to the institution resolving, less than 1% of civil cases, 1 to 4% of criminal cases. Does it teach us something about the unworkability of this system? I mean, we might feel attached to it as a matter of constitutional first principles, but is there some sense in which we simply cannot, I mean, for pragmatic reasons, but profound ones, cannot continue being committed to this system? And relatedly, is there some way of incorporating lay elements into our legal system that would be more pragmatic than the jury?
So I think that it's not the case that it's not possible to have the jury in a significant role. I think that what's happened is we've had a power grab. I think it's very much a power grab. You have the judiciary deciding cases that juries are supposed to decide, including criminal cases where the Constitution specifically provides in Article 3 that the trial of all crimes shall be by jury. Imagine the executive doing something that Congress is given in Article 1. I think that would be found unconstitutional immediately. But the jury is given this authority, and the authority is taken away. So I think what's happened is we've had a grab from other parts of government because we do not apply originalism in many areas relating to the jury. Those same actors who have taken the authority of the jury say, yeah, we really can't change the system. But I think we can change the system. We have to put resources towards it that we haven't done, at least in our recent history.
Renee?
I think it's telling that we see around the world a flight from the civil jury, and around the world a turn toward lay lay participation in criminal cases. I think that is important. It suggests that around the world civil juries do not work. It suggests that around the world there is interest in lay participation in criminal cases, and I think there are excellent reasons for those. The civil jury, it never was a terribly workable thing. I do research in legal history, right? And so I have lately been in the National Archives, and I was looking for records of jury verdicts in the 18 teens in certain states, or federal court in certain states. And I expected to find record after record of civil jury verdicts. After all, this is the 18 teens, before many of the mechanisms for getting rid of civil jury trial developed. And what did I find? Record after record of referrals to arbitration. I was basically reading a set of arbitrators' awards. I would say that about 50% of the civil cases at that time, the 18 teens, were referred to arbitration with both parties agreeing. So that just shows you, people don't want the civil jury. It is too unpredictable. It is too expensive. They don't want it. There is a consistent flight away from the civil jury that is ongoing. And really, there was a massive movement toward arbitration in the Middle Ages. Okay, that's when people's like, we don't want this. So I think that tells you something. And since then, the reasons to avoid civil juries have only gotten greater. The cases are more complex, are more reliant on written and even scientific evidence that is difficult for lay jurors to evaluate. And so there's even less reason to use civil juries than there ever was before. As I say, in criminal cases, there are reasons to use lay participation, and the best way to do it is in these mixed panels.
Steve is first.
Okay, thank you both for a very interesting presentation on an incredibly important topic. First, I wanted to somewhat take issue with Professor Lerner's claim that jury trial is spreading in criminal cases around the world. It is spreading in Japan, in Argentina, and in a few places. At the same time, in core civil law countries, as you acknowledge, Germany with Absprachen, Italy with pataggiamento, and France with a similar procedure, the name of which I can't remember, are all moving away from from lay participation and toward plea bargaining, in essence. There's a system where lay people don't play as big a role.
You're referring to abbreviated procedures.
Abbreviated
Yeah,
procedures.
yeah.
Second, you asked, Professor Lerner asked what I think is a really fundamental and important question, which is, what is the value of lay participation? And I think the value is it helps protect against corruption. It helps protect against boredom. And I can't tell you how many federal judges, including Supreme Court justices I've seen, who are inattentive to cases due to the fact that they're bored because they've been doing their job for too long. It protects against it can protect against ethnic bias if one ethnic group is in the government, one is not in the government. I also would take issue, Professor Lerner, with the claims specifically that jury trial is most valuable in criminal cases and not at all in civil cases. There's some civil cases like police brutality lawsuits where the government's behavior is particularly at issue. And so the case for lay participation in a police brutality suit might be very high, even if it's a civil suit rather than a criminal suit. I do think jury trial, if it's going to ever be restored, and I doubt it can be restored, would need to be reformed in a number of ways. And I wanted to ask Professor Thomas about a couple of reforms which I think are constitutional. I'd be curious to know if you think they're constitutional, that would make jury trial a more appealing institution. Number one, allow jurors to ask questions at trial rather than having to filter their questions through the judges. This would cause the jurors to be more engaged with the trial. Number two, require the jurors when they deliver their verdict to not simply deliver the verdict, but to explain why they voted the way they did. Not a written opinion, but an oral opinion. actually giving oral opinions is harder than giving written opinions, and it would do a lot to reveal whether there was any flaw or bias. Third, it seems to in my experience serving in district court clerkships and court of appeals clerkships, is that the document that we call the charge, which judges provide for a jury to take to the jury room with them, laying out all the specifics of the facts and the law, are mainly written to be appeals proof, and charges are not understandable by jurors. So in lieu of having a charge, I would wonder whether it would be valuable to allow the judge to go to the jury room, answer such questions as the jurors have, and then leave and let them deliberate in private. That seems to me like something that would be much more valuable potentially than the charge. Another reason jury trial is so difficult to have right now in the United States is because it's so time-consuming and expensive. I mean, essentially what we've done is we've converted juries into something like, as Professor Langbein once said, an extremely expensive sports car that you can only drive on Sunday afternoons when the weather is good. That's not a useful institution for decision making. So I wonder if we should take our inspiration from Scotland and not from England. And in Scotland, juries decided cases but by majority verdicts, not by unanimous verdicts. And there were 3 verdicts available: innocent, guilty, and not proven. The Constitution simply says we have a right to jury trial. Can we, within the constitutional constraint, allow jurors to do the things that I suggest might make jury trial more manageable?
Thank you for your questions. So I think that if we look at the substance of the jury trial in England in the late 18th century, all of the things that you propose, except for unanimity, not having unanimity, would be permitted. I think if we look at reasoning, sometimes judges would ask. It's funny, in my book, in the last couple of pages, I proposed the reasoning requirement, a reasoning requirement. I've backed off of that sort of in my mind since then, and one of the reasons is on the criminal front, I do think that the jury has the ability to nullify, and as a result, I'm not sure that the reasoning, at least on that front, would be relevant. But I do think that it's that it could be implemented without it being unconstitutional. And then in terms of asking questions, similarly, I think that substance-wise of what existed in the past, that would also be appropriate. And on the charge, I couldn't agree with you more about jury instructions, and I think that that's lawyers' our fault and judges' fault, and a lot of work needs to be done on that front. But I think judges being more involved would be very helpful. And then in terms of unanimity, I think I think it is fundamental to the system. And it's interesting because in some states, right, you don't have unanimity required in civil cases, right? And the 7th Amendment hasn't been incorporated against the states, even though it should be, in my opinion. And I write about that. But to me, that it should be unanimous in those circumstances too, and we would actually probably have less criticism of the civil jury if in fact there was unanimity in those states that don't have unanimity. So that's how I would answer. Thank you.
Just one intervention here, and then we should hear from Renee. But part of the question was, are these modifications in how the jury works constitutionally possible?
Yeah, I said yes.
You said yes to
yes.
that? Okay.
Yeah, because historically,
I missed that.
yeah.
Sorry.
Mm-hmm.
Yeah, Renee.
I want to address Steve's point about the abbreviated procedures, which are spreading, to be sure, in other legal systems. So we're not the only ones who do plea bargaining or a form of abbreviated procedure, although we are the most extreme. I think there's no question that we are the winners in that respect, if you want to look at it that way, with over 95% of cases being pled guilty. But abbreviated procedures in criminal cases are spreading around the world. I described briefly the Absprachen procedure in Germany, which involves essentially an arrangement between the judge and the defense lawyer to avoid a full adjudication. And there are similar procedures in other countries as well, in Italy and in other places. Italy has adopted a very interesting procedure of trial on the file, where basically they will give the defendant a discounted sentence for the judges to decide the case on the written file, which is the pure inquisitorial system. So it's interesting that Italy has found the pure inquisitorial system to be more efficient than the use of lay jurors. But in any event, but I think one of the reasons we're seeing this movement around the world toward more abbreviated procedures is that criminal cases have grown more complex. Now many things are made criminal offenses that were not previously. White-collar crimes, environmental crimes, these kinds of things, which are very difficult to adjudicate. They involve a great deal of evidence, much of it scientific expert witnesses, etc. And that drives up the cost of adjudication, of investigation and adjudication. And so there is incentive in these systems, and including ours, to try to get rid of those cases in a more efficient, briefer, and less expensive manner. So I think that's part of what's driving this worldwide turn toward abbreviated procedures. In terms of the police brutality question, there may be, in certain types of civil cases, reasons to have lay participation. I'm not saying that it should be cut out entirely from all civil cases. I think it may be that in those types of cases that there is a reason to have lay participation. Again, I would suggest that it be done in a mixed panel, where you have professional judges and lay jurors looking at evidence, deliberating together, and so forth. So it is, could be possible to have that kind of thing. And I think the fact that many of the recent police brutality cases where there was a question of criminal charges went to grand juries, and the grand jury resolved the case, I think aids greatly in the public perception of legitimacy. And I think that's an important reason to have lay participation in criminal cases in particular, that I don't think has been mentioned yet.
So the next question is to Steve's left. I just want to mention the queue is open. Okay, right. 3 and 4. Yeah, please. The gentleman from Steve's left, right there.
Hi, Randy Barnett. My question, I guess my comment or question is to Suja. It's on a topic that hasn't really arisen yet. There's a good textual and historical argument to be made that the due process of law was originally a directive to the judiciary, the judicial branch of either the federal government or, in the 14th Amendment's case, to the states, and that the core meaning of the due process of law was a reference to jury trial. That is, no one should be deprived of life, liberty, or property without a jury trial. Of course, we also know that the original meaning of the jury included a consideration of both the facts and the law, which means that the Due Process Clause, if interpreted this way, has a substantive component, and that is that the jury may consider the substance of the law in order to decide whether it's properly applied to a particular defendant. This is commonly referred to nowadays as jury nullification, but it's nullification that only takes place in a single case. It's not like judicial nullification that happens across the board and the statute is supposedly void at that point. This is just a case-by-case nullification of the jury. Suja, is this covered in your book? Is it something that you're interested in? Is this something that you have found in your research about the jury? How promising do you think this line of analysis is for an originalist analysis of the jury?
So I think that's a really interesting question, and it's something that has actually kind of been in the back of my mind. I kind of constantly think about it when I'm thinking about the Due Process Clause, but I have never done the originalist research relating to this question. The only research that I've done relating to the Due Process Clause is research relating to incorporation. It didn't kind of specifically, I can't tell you that I can, but I am very drawn to that argument, and I believe that if you play it out, that in fact, I think it would come out the way you're describing it.
I mean, one thing, when you think about it, is that you wouldn't really need, quote, incorporation if the due process of law is the core of the due process of law, if not, almost not the exclusive content of the due process of law is a jury trial. Then incorporation is irrelevant.
Absolutely.
And the other thing I would just mention when you start to look at it is there's lots of different kinds of evidence about the original meaning of due process, but one of the interesting things is if you study abolitionist constitutional writings that take place in the early 19th century, they do talk a lot about the due process of law. They seem only to talk, and they're very, very creative in coming up with all kinds of arguments against the constitutionality of slavery or one aspect of slavery or not. But it turns out, when they talk about the due process of law, they almost only talk about the jury trial. And that, in fact, slaves were not deprived of the property they had in themselves with a jury trial, and therefore that's why slavery might be considered unconstitutional. But that's as far as they go, and you might look at abolitionist constitutional thought as a source of information about that prior to the 14th Amendment.
Great. Thank you.
Can I make one comment on that? I have just one comment in response. Jury nullification giveth and it taketh away.
Over here.
Yes. Hi, Bob Cottrell, George Washington University. I very much enjoyed the discussion between the two of you. Renee, I have a question that I'd like to ask. You place a great store on predictability and the difficulty that civil juries pose for predictability. Let me say a couple of words in defense of unpredictability and perhaps the importance of the jury to that. Does predictability give wrongdoers an incentive to essentially sort of game the system? Because if you know that there are only relatively predictable actors, let's say judges, in the system, you can calculate the cost of wrongdoing. The classic case I can think of is the Ford Pinto case of the 1970s, where basically they sort of sat down and said, well, rather than putting this $5 widget in, which will prevent the Pinto from exploding, we'll take a number of cases where it does explode, and basically, the judges all know some variant of learned hands formula, and they will basically come up with predictable verdicts and damages, and it costs less to pay those than to go through and put in the $5 widget. And it made perfect sense from that kind of cost-benefit analysis. And then till one jury decided they were going to simply nuke Ford Motor Company for doing it. I want a jury of lay people in cases like that. I want people, rather than people who calculating, something extrapolation of learned hands formula, I want a jury of 12 people who said, gee, I just gave my teenage kid a Ford Pinto, and they didn't think enough of his life to put in a $5 widget to stop him from, being in this horrible explosion. I'm going to, sock it to him with everything I possibly can. The jury allows that sort of thing in a way that I'm not sure that insiders, like judges, would allow that to occur.
That is true. We look at the Ford Pinto situation. I actually, my parents had a Ford Pinto at the relevant time. Fortunately, it didn't explode, and I rode in it many, many miles as a child. But in any event, yes, clearly we're concerned about that kind of trade-off. I think that, I hate to say this because I'm not a fan of regulation in general, but that seems like a classic case where regulation can help, where some sort of administrative process and rule could help. The thing is, juries, being so unpredictable, they will thwart not only bad actors on occasion, but they will also thwart good actors. So people who want to do something productive, want to start a business or something like that, and they can't predict what their costs will be as a result of having to face jury verdicts. So with the example I gave of the trucking industry, just recently, just in the past year, these two major insurers pulling out of the trucking industry, even though fatalities involving major trucks have fallen quite a bit over the past decade. So that's the problem, is that you're not only thwarting bad actors, you're thwarting many, many good actors as well. And so to thwart the bad actors, I'd rather see some more predictable system, such as administrative regulation. I hasten to add, I am not a fan of many, many regulations. And I think an important point that we haven't really, as Suja raised it a little bit in her initial remarks, an important point is the administrative state being potentially out of control, and the jury possibly acting as a check on the administrative state. And I suspect Randy and others will have similar sorts of interests. I would say to that, do not rely on the jury. That is a weak reed to rely on. What we should be doing instead is legislation that eliminates, preferably entire agencies and departments, but barring that, at least many, many rules that are not helpful. But there are a few rules that might be.
Did you have your hand up? Yes, please. I think you're next.
Joseph D'Agostino with Savannah Law School. So to a considerable extent, the two of you have been talking about different things. I think Suja's been talking mostly about a principled argument that the Constitution requires the juries and the involvement of juries, whereas Renee, you've been talking about the pragmatic advantages of not using juries, at least for civil trials. But I wanted to focus on the more pragmatic, what we would do if we could do whatever we thought was best regardless of the Constitution. Because I think that could be really convincing and persuasive. So using actual empirical evidence. So I wonder, Suja, if you could elaborate a bit, not on the potential problems with getting rid of juries in civil contexts like we talked about, but what has actually happened? Did bad things happen when the civil juries were abolished in England? What can you point to in England, Canada, Australia, New Zealand, as well as the continental countries that are problems caused by the lack of the civil juries? Are there deserving plaintiffs losing out that they otherwise, cases they should otherwise win, or the damage awards too big, too small? I mean, can you point to things empirically, that very bad things that you can point to and say, look, what happened in England, look what happened in Germany, because they don't have civil juries, let's not share their fate?
So I haven't done any empirical studies on that, and I don't know if there are such studies, but I need not go there, as we have our own system where we don't have these juries, right? And what I would point to is that we have case after case after case, especially civil rights cases, that are decided by judges on summary judgment. And they're factually intensive cases. And I have actually another book coming out with a co-author in May. And that book talks about all these different ways that these procedures are used to dismiss employment discrimination cases. So we really don't have to look anywhere else. We can look to this country, and this kind of goes a little bit to Renee's point that a litigant they don't want juries. They do. There are a lot of litigants that want juries. Yeah, some cases settle, and some corporations agree to arbitrate, but a lot of us have signed. In fact, every one of us has signed, or not really signed, but we have arbitration agreements, right, with our cell phones and cable companies. And I can tell you, none of you want probably an arbitration if you have a problem with your cell phone. You want, if you can, you would want that case to go to a jury and some class action lawyer to take that case So anyway, I would point to the evidence that I have, which is that, there are a lot of people who want juries in this country, and they don't have them. And I'd point to the problems that judges have that are similar to what juries have, and the positives that juries have that judges do not.
If I could add something to this question. So I'm sympathetic to the kind of consequentialist approach. I just find myself incapable of being persuaded on the basis of first principles of some outcome on a question like this, question of institutional design. I want to hear about consequences. In the criminal context, there is a very important body of empirical research, largely from John Pfaff, though not exclusively, which indicates that the primary cause of mass incarceration is the rise of plea bargaining. So the massive increase in incarceration since the early 70s is primarily caused by plea bargaining, which is to say, if you're looking for consequences related to the reduction of the jury in the criminal context, the consequence is mass incarceration.
On the reduction, ultimate abolition, essentially, of the English civil jury, we do know a few things about that. One of the things we know is that in the mid-19th century, when this process began, the legal profession was gung-ho in favor of eliminating the civil jury. Why was that? Well, it was because English judges had tremendous power over the civil jury with their comments on evidence, which were extensive, and the judge could essentially give his opinion which side he thought would win, and he would do so often in strong terms, and then he would say, but of course, gentlemen of the jury, it is for you to decide, right? And the jury took the cue and ran with it. So the legal profession believed, and this shows up in many newspaper articles in England at the time, the legal profession believed that it wouldn't make much difference to the outcome of cases if you abolished the civil jury, because the judge so dominated the civil jury in England anyway. And that what you would do is basically spare the expense of having to call the jury and the jury fees and so forth. And empirically, that pretty much turned out to be the case. Once you abolish the civil jury, you save the jury fees, but it didn't make a whole lot of difference to the outcome of most cases. But that was because of the powers of English judges. Incidentally, American judges had, especially federal judges, had a similar power, and some exercised it. And this lasted into the 20th century. So the powers of judges have changed quite dramatically, and in ways that many people think have made jury trial more unpredictable and less efficient. So that's something to think about there. So we do have some evidence about what happened and the reasons why. In general, I would say this. I would say procedural rights are deeply problematic. Different from substantive rights. Substantive rights have a core there that you can adhere to. Procedural rights, such as the jury, can be very easily manipulated. If you change the procedures surrounding a particular procedure in a legal system, you can change the meaning of that procedure entirely. And that's exactly what happened with plea bargaining on the criminal side. Once the judges allowed the prosecutor to offer a deal to the defendant, here, plead guilty and I'll reduce your charge. Once you allow that, you've entirely changed the meaning of the right to the criminal jury. And as I say, procedural rights are very vulnerable to that type of manipulation in a way that substantive rights are not.
We're out of time. Well, that is to say, we're out of time, but for closing statements. So apologies to the people who had their hands up. Suja's going to speak for just a few minutes, and then Renee.
So it's a pleasure. It's been a pleasure to participate in this debate, and I thank the Federalist Society for having me. Originalism has an important role to play in the interpretation of the Constitution, and I think it's particularly important in protecting the role of the jury, which can't protect itself. There are 3 different provisions in the Constitution that provide for jury authority, but despite these provisions in the Constitution, the jury has very little authority. And the jury's position in our government contrasts greatly with the position of the other actors in the Constitution, the executive, the legislature, the judiciary, and the states. We actually even criticize some of these other parts of government for the same things that we criticize the jury, incompetence and inefficiency. But these parts of government actually thrive. And the Supreme Court has recognized constitutional text. It's recognized the role that the jury, that these players were supposed to play in protecting against each other. And then it established separation of powers and federalism to protect them. But you can contrast that with the jury because the Supreme Court hasn't recognized the jury's text, the jury's historical position, and as a result hasn't established any kind of separation of powers or federalism type doctrine. And this has resulted in the jury having really little role in our government. So I think that if we actually adhered to originalism in this area, as Justice Scalia has done over and over again, I think that through the use of originalism, we can restore the jury, but we just have to be true to the constitutional provisions that are in the Constitution about the jury. Thanks.
Good. I think it's time to stop treating the Constitution as a sacred cow. I think it's time to look at it as a law, which it is, and to amend it. If we think that civil juries are not working, and I think we've amply demonstrated that at least litigants have amply demonstrated they don't think it's working, most litigants would rather settle. I mean, yes, it's true that in some classes of cases, maybe they would like to get to a jury but can't because of judges. But most litigants would rather settle than go to a jury trial, the vast majority. And if it's not working, I think it's time to amend the Constitution. The Seventh Amendment, as it is now, blocks the development of a proper legal system that adjudicates cases appropriately. I think it's time to amend it, change it. As I said before, there are certain ways that it can be done even with the existing Seventh Amendment. I think it's time to get serious about that and to get serious about our legal system. I would say that even Hayek, who is the greatest fan that there ever could be of the ground-up approach and the customary law approach, even he said, in certain areas, you must design a system. And he said those areas are the organization of the government, which the Constitution, as we have it now, well sets out, and the legal procedure, the legal system. These things need to be designed as a whole and not just sort of modified piecemeal here and there, because every part affects every other part. And I think it's time for us to sit down and address those seriously.
All right, thanks everyone for coming. And a last reminder that we're going to continue proceedings on the 4th floor. Thank you.
Thank you.
That was really, really